Hello, everyone, for taking the time to join us at Legal 500 webinars. We're now doing a really interesting topic titled The Contemporary Analysis of the Prime Objectives of Competition Law. This is alongside an association with Elig Gerknick partners, and we've collaborated with them on a few previous webinars. It's been a real illuminating experience. Competition law continues to be a core legal issue to both modern day corporations and states due to the shared interests in avoiding abusive behavior in the market, staying informed about developments and the ever-evolving legal complexities and frameworks relating to competition law is therefore of particular importance to everyone. The webinar is brought to you, as said previously, by the Legal 500 and Elig Guknak attorneys at law. It's going to cover a broad range of core topics on this. Founding partner of Elig Guknak attorneys at law is Gonyank Guknak. He's founding partner of a law firm of 98 partners based in Istanbul, Turkey. He graduated from Ankara University, Faculty of Law in 1997, and called to the Istanbul Bar in 1998. We're also really happy to be joined by Global Competition Professor of Law and Policy at George Washington University, William Kovacic. He's also a visiting professor at King's College London from August of 2013 through March 2022. He served as non-executive director with United Kingdom's Competition and Markets Authority. We're also joined by Ioannis Kokoris, professor of competition law and economics in London and dean for international faculty of humanities and social sciences in Paris at Queen Mary University. So at this point, I want to pass everything over to the speakers right now. And if you have any questions, please add that in the chat below, and we'll pass it over to the panelists. Again, I want to thank everyone for taking the time to speak with us today.
Thank you, Nathan. Thank you for the brief introduction. Without further ado, while we're in the presence of two leading minds of competition law, one being Bill Kovacic, no need for introduction. He's probably the most well-known figure in competition law today, and he is putting in such incredible time and energy in spreading the word of competition law in very many different fora. And in the presence of Ioannis Kokoris, who is a leading academician of competition law in Queen Mary University, London. I'd like to introduce to the audience that today we're going to talk about prime objectives of competition law in view of contemporary developments, changing policy preferences, and how do we fit the new dynamics of markets into these prime objective perceptions. And with that, we start with the first concept that we need to place: where does innovation fit? We know that innovation is the true engine of economic growth. We know that if we were to look into different types of economic efficiency, which is a proxy to welfare maximization, which is ultimately one of the goals of competition law, or the goal of competition law, the dynamic efficiency takes a very significant place among allocative efficiency, which is distributive efficiency, and cost efficiencies. But dynamic efficiencies having the lead in its potential for economic growth and welfare doesn't mean that it is very calculable. It doesn't mean that the mysticism about it has been dispelled, and it doesn't mean that the competition authorities around the world have embraced it entirely. So the question is, where are we in the struggle to integrate innovation candidly into our competition law enforcement analysis? Over to Bill first, and then to Johannes, if they please.
Gonench, thank you so much for allowing me to join the conversation, and it's delightful to be joined up with Johannes to do this. I'm most grateful for this opportunity. I want to start with some positive developments, which include first, I think, a broad awareness of the crucial role that innovation plays in promoting growth and economic progress. The condition you just referred to, Gonench, I think there is a broader understanding of a point that was established over a half century ago when Mike Shearer wrote his formative industrial organization text, Industrial Organization, Market Structure and Performance. Mike's book very bluntly stated that the single force that accounts more than any other for economic growth and progress is innovation. And that if you move the innovation needle forward, you get more benefits for the larger society than you do by any other form of policy intervention. I think the essential insight of his work and that of many others is sinking into the competition policy community. That's where you get tremendous breakthroughs. That's where you get the exceptional enhancements in productivity, product performance that create employment, create wealth. The difficulty has always been that it's hard to take dynamic effects into account. There is a tendency in a lot of antitrust analysis to look in the rearview mirror instead of looking ahead at what's taking place. And then even when you do look ahead, trying to make sensible predictions, there is the difficulty of making an accurate interpretation of what you're seeing. I think a positive development to address this problem of knowledge and capacity is what I saw in my time at the Competition and Markets Authority. They made a massive investment in carrying out market studies that are designed to build deeper understanding of what's happening in the relevant technologies. And the second thing they've done is to build a team, which now numbers 50, of technologists, data analysts, analytics specialists who are in a much better position to understand the phenomena that they're observing at the moment. So I think this effort to build the right human capacity and to supplement it with a research agenda that puts you in a position to understand what you're looking at are very positive developments for the evaluation, for example, of mergers, the examination of single firm conduct, the evaluation of collaborations among rivals that are ostensibly designed to enable them to achieve greater technological progress. So the very positive trends I see are, one, a broader growing awareness of the centrality of innovation as a source of economic growth and progress. Second, the efforts by a couple of leading agencies to establish a better foundation for taking innovation-related considerations into account. And third, building the human capacity to do an appropriate diagnosis of observed phenomena. I think those are all encouraging developments. And I'd add a fourth to that. There's a growing effort to study past episodes of enforcement to see how competition law, as applied, has either advanced or retarded the innovation process. And I think some of the lessons of that is that it underscores the benefit of ensuring that incumbents are not able simply to suppress new innovative ideas, to ensure that government restrictions, government regulation does not needlessly impede entry into the market. And it also identifies useful ways in which, yes, government funding can provide a useful stimulus for technological change that might not happen without the fact of the funding. So these I see all are positive developments, but I don't want to understate the extent to which the hardest problem for competition agencies is taking account of technological dynamism, understanding what it is, understanding how it affects the market process, and choosing government intervention strategies to ensure that it operates successfully.
This is wonderful. Thank you, Bill. Enlightening as always. Let me pass this to Ioannis, but instead of asking the same question to both of you, and always assuming that you are going to chime in on what each other are speaking about and thinking about anyway, let me also push in the matter of sustainability in there as well. I'm sure Ioannis would want to talk about innovation being one of the virtues that the competition agencies around the world would want to protect, and they are doing a job to protect it. Whether it's a good job or not is still for debate. But sustainability is now making a debut for the last few years, especially in the competition law jargon. It is, of course, of tremendous importance as a concept, and without it, there will be nothing, basically. But then again, it is well possible to be diluting the objectives of competition law if sustainability goals were to be understood in a way that allows for agencies to engage in scaremongering, or agencies to take things in a non-technical manner. So how do we strike the balance? Innovation was a concept that wasn't found calculable for a long time. Even in merger control analysis of today, you see that when agencies are articulating problems at the sphere of innovation, it suddenly feels very articulable and very calculable. But when companies are pulling it as a defense, it is seen as, you're talking about synergies. It's very, vague. So we're not going to adopt it as a defense. Are we also risking sustainability issues being a victim to agencies paying lip service to it? Do we think that we're getting closer to a tipping point in terms of sustainability in the world, and yet competition law is never embracing concepts as aggressively and quickly as it should? Let me turn to Ioannis with all these thoughts.
Thank you, Janan, and it's always a pleasure to be on a panel with Bill, and thank you for the invitation. Let me start reflecting on sustainability by bringing in a few comments on innovation. I will explain why, because if I look at innovation sustainability, I find innovation a more convincing argument in my mind at this point than sustainability. This may have to do, this is most likely have to do with my lack of full appreciation of the potential that sustainability considerations can have in enforcement, which goes back to a point Bill made earlier that some authorities have gone about innovation, for example, like the UK, by doing a market study, trying to understand the market, how the market operates, before they decide to actually intervene in certain ways to ensure that innovation is supported. Some other authorities on a number of areas have decided to actually enforce without potentially allowing themselves the space to understand exactly how the market that they're enforcing in is actually operating, and whether that enforcement can have any collateral damage or not. So sustainability, it has been in the radar, as you said, for 3 years now or so. We already have the Dutch authority and the Greek authority. There may be others who have come out with guidance, technical guidance. I've been through the guidance. It's a very well done piece of analysis. The concern I have on sustainability, actually two concerns I have on sustainability, is I can see the guidance. I understand, I'll be honest, most of it, not all of it. That's due to my own ability to understand it. What I am not sure of is whether a competition authority will at this point be in a position to decide on a competition case with the main theory of harm involving arguments of sustainability. If we look at innovation, innovation was already in case law in the early 2000s. We have mergers of Glaxo all the way 22 years back. It did become a much more hot topic, let's call it, in 2015 to 16 with the 3 deals in the agrochem sector, in global deals, where the Commission also adopted a much more forward-looking perspective on how should we take innovation into account, over what horizon, and how can we incorporate it in assessment. And it's a different thing to be looking at merger assessment when you need to argue as a competition authority the foreseeable adverse impact that a deal can have on innovation. And it's a different story to look into a conduct case where you should, or you will most likely have evidence of a conduct harming innovation. So innovation became very relevant in the last 5 to 7 years, but it has been something that has been in case law and has been in the guidance for 20 years or so. So even though we have not used it possibly as much, because possibly competition authorities had, let's call it, easier theories of harm to argue, and possibly did not went on the way to innovation, it's been there. It is in the legislation, secondary, and it is in the case law. Sustainability is something which now is really at the forefront of discussion for very good reasons. I think it's obvious why we need to be concerned about the environment, why we need to be concerned about other areas of sustainability, resources, for example, supply chain. What I'm not so convinced of at this point is the competition authority, the agency that should be the one to incorporate sustainability priorities? Or should there be other agencies or other ways to actually improve sustainability outside the realm of competition enforcement? I just feel that, and I will pause here, I just feel that competition authorities are always asked to do more and more, to take into account more and more, let's call them objectives or priorities. And I think they are very clever people, very able people. I just do not think that they can be an umbrella agency for any consideration which we need somebody to act fast and effectively. And I'll pause here and we can continue.
That's very interesting. Thank you. Just to follow up on that with a small question, Ioannis, would you believe that if there were to be a separate body securing sustainability goals, they would understand competition law well enough to instruct competition agencies to strike a correct balance? So, because part of the problem is that there will need to be a balancing act.
You're definitely right. Part of the problem is that it has to be a balancing act. And I think part of this balancing process is to understand exactly, as competition world or competition agencies in this particular matter, understand exactly how some markets work, how, for example, can competition enforcement contribute or not to sustainability consideration, in what type of markets. So it goes back to the point Bill was making about CMA is doing a market study, understands what's happening, and then decides how to incorporate the consideration. So I would be in favor of that approach than an approach that would become a blanket adoption of sustainability considerations in competition enforcement. And I don't think that's where we are, though. I don't mean to say that this is where we are.
I see. Interesting. Bill, going back to you, now that we're in the sustainability topic as well, how are agencies actually going to integrate sustainability goals into their enforcement agenda? What are the political implications of this? Are we at the desired level of transparency in terms of policy preferences and implementation methods of agencies that would allow for a healthy integration of sustainability goals into competition law enforcement agenda, obviously without diluting the articulable and calculable economic efficiency goals, at least beyond more than what is absolutely necessary?
I think an important starting point, which a number of agencies have raised, is to identify the extent to which existing interpretations of competition law and policy may get in the way of the achievement of sustainability objectives. There's a growing literature that suggests that the threat of prosecution under Article 101 or Sherman Act Section 1 type standards is discouraging firms from engaging in necessary collaboration. Collaboration to set better energy efficiency standards. Collaboration that might result in the withdrawal of certain products that have energy intensive consumption design features, and to use collective action to achieve reductions in carbon emissions. So that is a frequently made claim about the existing environment. If not other forms of cooperation that would be possible, I think a starting place is to identify more precisely which scenarios are raising the concerns. That is, what are the specific undertakings, projects that firms would like to carry out, but feel reluctant to do so now because of the overhang of either public enforcement or private enforcement that would seek damages. I think to identify those more clearly, I think in a number of instances, existing doctrine would tolerate different types of collaboration. That is a collaborative process to develop a product or service that might not otherwise be available. I think there's a lot of room in the existing framework to accommodate those concerns. So a beginning point is a deeper conversation within the larger community, but certainly between business and the competition authorities to identify the relevant scenarios and potentially in a number of instances to use mechanisms that are available to seek guidance, business advisory letters, opinion letters, techniques which were used with great speed in the face of the early phases of COVID, but to begin by identifying the scenarios that pose concerns, the projects that will be foregone, arguably, if there are not some adjustments in the application of competition law, and then the use of these advisory mechanisms, perhaps to test specific measures. I think the greatest conflict is going to come where the effect of collaboration is to withdraw a product that has a lower price but higher energy consumption, and to channel users in the direction of higher priced products that have greener effects. And I think the anxiety for competition agencies is that trade-off is very hard to perform. That is, what reduction in carbon would justify a given price increase? What's the exchange rate there? And I think another question is, as we open the door to this kind of analysis, and Ioannis, I think, was pointing in this direction before, do we see similar requests made to effectuate other social policies? What if a group of food purveyors, restaurants, decided to withdraw items from the menu that have a demonstrated tendency to increase obesity, which is poison for pathologies like heart disease, pulmonary problems? Suppose a group of merchants decided to withdraw other types of products that are known to have, in some instances, negative externalities, where there may be a collateral regulatory regime in place, but it seems not to be working. I think the anxiety for many competition agencies is how far would private initiative be allowed to go to serve a wide array of other social and economic policies? But I get a starting point on sustainability is, what are the scenarios of concern? What would firms like to do that they feel inhibited from doing now? And use that as a starting point for discussing what specific applications of competition law might alleviate those concerns, and which cannot be reconciled.
This is very clear and helpful. And also, I must add, the current situation in terms of the guidelines covering sustainability in Europe, they don't seem to meet these standards at the moment. I don't feel that they go far enough. It just feels to me that there is an effort, but it feels like a prelude. Rather than actually giving a guideline to businesses that are worried about competition law enforcement and therefore are hesitant about coming up with a new product. So
yeah, Gonench, I wonder if one thing agencies have to do, for example, is to experiment more with convening workshops, holding other consultations that say, tell us what the problem is.
Exactly. And maybe, and I don't want to be that guy that says this, but maybe then sustainability is going to come across as a bit of a hot air because the businesses aren't prepared to articulate, concrete sustainability goals, in which case it's a wake-up call for the businesses. It's a different type of wake-up call for enforcers as well. So we don't even know exactly if we are serving interests that are ready to launch. On that, I'd like to ask a question that Nick Peristarakis is asking, and that is, could it be that consumer welfare maximization might be a too narrow of a prime objective? And would there be a virtue in expanding it? So he doesn't include this bit in his question. I don't know if what he means is by way of, moving on to more like a total welfare type of approach, or is he talking about let's get rid of the welfare maximization paradigm a little bit and move into the fairness spheres and other spheres that are long discussed now. But in any case, would you believe, Bill, that consumer welfare maximization as a prime objective happens to curtail our ability to integrate sustainability or even innovation, because dynamic efficiencies cannot fight as efficiently with distributive efficiencies and cost efficiencies. So agencies are constantly asking for a demonstration of price effects, and they're not as impressed with dynamic efficiencies because they're so hung up on consumer welfare goals. Could that be the case?
I think our field is cursed with the vocabulary of consumer welfare. I think that in so many ways it impedes a discussion about what we're trying to do and how to do it. It's a term that has to be carefully defined, or the discussion simply spins off into low Earth orbit. I have always thought, when I look at what the agencies I know best do, they have tended to define the well-being of consumers in a way that encompasses a variety of other values. That is, to start with, we have to say, well, what do consumers want? What do they value? Are they single-mindedly concerned with price effects? I suspect not. Do they want better quality? Yes. If you ask them, would you like competition law to facilitate innovation that achieves economic breakthroughs? Of course we do. At some level, is it in the interest of consumers to have air that they can breathe? Is that important to their welfare? I'd say yes. My experience in a competition agency is that the agency, the Federal Trade Commission, which I knew best, but the CMA, were never single-mindedly concerned with price effects. And when I count up all the cases in which innovation effects, quality effects were preeminent, and I'm thinking, as Ioannis was mentioning before, I'm thinking about cases in the pharma sector. I'm thinking about cases in aerospace and defense, where in case after case, the asserted basis for intervention was quality and innovation alone, without regard to price. I'm thinking in cases involving real estate transactions where the basis for the FTC's intervention was to facilitate the emergence of a new disruptive business model that was changing the way in which real estate transactions took place, and a host of other merger settings as well. So I think an important step in answering your crucial question is, well, what have agencies actually done? Have they been so blind to these other effects? I think that when we look at our collective experience, we'll find that they've taken on a wide array of considerations that go beyond price. I wouldn't assert that they've actually always been skillful in handling dynamic efficiency concerns. But I would say that it's extremely instructive to look at their collective experience, looking at mergers involving aerospace and defense, and to look at the analytical methodologies they have developed and refined in order to anticipate, predict, and weigh innovation-related consequences of individual mergers. I think they've learned, maybe they have forgotten some of what they've learned, but there's an extraordinary body of experience that shows both the analytical techniques, but the awareness of the importance of considerations that go beyond price. Now, is that framework elastic enough to take account of sustainability arguments that we've been discussing? I suppose I think in many ways it is, but I guess I'll end my lament about consumer welfare to say, perhaps we need simply a new way of describing what we're doing, because to mention the words consumer welfare is to set people on edge right away. And I don't think it's a helpful description of what agencies have actually done.
Can I just add one comment to Bill's comment? I fully agree with. I think I fully agree with you. Consumer welfare, we are past the days that this was a static assessment. And authorities have been creative enough to incorporate within these two words any consideration that has been deemed important for the market or for consumers or for competition in a different variety of cases. Changing it to something else, I think we will be having the same discussion about the new welfare we adopt in another 20 years from now, whether that new welfare may be too wide or too narrow. I think as long as competition authorities are adapting to the realities they face within the regime they have, how we call it, I think is less problematic.
Interesting.
I guess
Chad,
I'd say my main thought is that again, when I examine what agencies have actually done under the aegis of consumer welfare, I find their methodology to be richer in examining a wider variety of effects than we might think ordinarily.
There is, of course, another fallacy as well. When they're looking into narrowly tailored goals of consumer welfare, and when they're requesting that there be a solid demonstration of dynamic efficiencies in a given file, it typically so happens that whenever there is a pipeline in a given industry, they are more prone to articulating fears about the future of dynamic efficiencies in those particular markets. Just because there is an FDA in a given market, just because there is a process of first phase, second phase, third phase in a given market, it should not mean that those markets are more prone to future, collapse of innovation spheres, as it is called. But ultimately, we see agencies engaging in that kind of a practice way more in these kinds of industries, because they can see the evolution of a new product and they can project into the future better, which then kind of leaves us in the situation of the person looking for his car keys under the street lamp. Have you lost it there? No. Why are you looking for them there? Well, this is where the light is, so that's why I'm searching for it there. That's, I think, one of the traps the competition agencies are falling into at this stage about enforcing too much with fear that innovation is going to be curbed, particularly in pharma markets. And there are interesting examples of enforcement that is getting in the way of developments from sustainability end as well. Moritz Dolmans has just sent an interesting example. He says the IEA says stop insuring and financing unabated coal power plants. And that's a collective boycott, if you were to boil it down to an offense. Yet there is no intent of raising fees, so this is not really a cartel. And there are clearly, positive externalities that are being created. But competition law would be an issue, and Financial Times is covering this, as Moritz has also flagged, and I saw that as well recently. Another example is sustainability in fashion. So there are examples. I wanted to use Moritz's examples here also to get it under record that Bill's idea of having workshops and understanding what fear we are instilling in people that stays them from coming up with better products or a better future is quite critical. With that, turning to Ioannis, if you allow, I would like to broaden the horizons a little bit more. Now we seem sympathetical to sustainability. We are already sympathetical to innovation, but where do we draw the line? How about national security, the fight with inflation, protection of small companies, racial injustice, as the South African agency seems to also follow as a goal, especially in merger control cases, employment goals. Some agencies do it. The South African agency definitely does it in merger control matters. So how are these different from sustainability and innovation, or are they? Or should these be also goals followed by competition agencies? But then is competition law the correct tool to address all of these matters, and where does it end? Over to Ioannis.
So you raised a number of different potential objectives there. So national security, inflation, employment. You mentioned South Africa. The South African regime is clear that in their assessment, in the public interest test they take into account, employment is an issue that they feel is important and they feel they need to take it into account. So they are explicit that this is a consideration that in our jurisdiction is very important to us and will be part of the assessment. Different competition authorities will incorporate different priorities, which as long as they are explicit and transparent about it, I have total conviction that they will be perfectly able to actually enforce the law, take into account this consideration. So I'm not against having an employment condition there. I see that if you ask two merging parties, you cannot merge if you lay off individuals. I'm not saying this is the exact test in South Africa. And in most cases, after a transaction, you may see some layoffs. Then you may reduce the commercial rationale for a potential investment, for a potential transaction when it will be into amalgamating business lines. But we cannot have a one-stop shop, or we cannot have a one-size-fits-all. Actually, that's a better phrase, a one-size-fits-all when it comes to enforcing law globally. And as long as competition authorities are transparent on the priorities they have and what they will take into account, and they can be quantifiable in some fashion, I can see that this can lead to more certainty than leaving it vague. I wouldn't put national security there. When it comes to the competition authority involvement, I would take national security out in the sense that there are two broad models globally. There is a dualist model where you have two different agencies doing that. So US is an example, UK will become an example like this. France is an example like this, for example. And you have other models where one authority is doing both and with input from others, what UK used to be. National security is something quite different and quite more non-transparent than any other aspect we're discussing now. And That's why I think most competition authorities have decided, and most regimes, most governments, most countries have decided to actually separate them. I don't think we should go back into incorporating national security in merger assessment by a competition authority. If you look at the recent CMA issue statement on Megit, it identifies potential issues, and also on previous cases has done the same. And then when it comes to the national security part, this is blank because, of course, it's confidential and because this cannot be disclosed. So national security is not the same as taking into account sustainability considerations or innovation or employment. I think national security is something quite distinct and should be dealt quite distinctly from a competition assessment. Still, both will have an impact on an M&A deal, but it should be done under a different approach because it has a different set of skills required and a different set of sensitivities required. So CFIUS, for example, which goes back to 30, 40 years now, is an agency that does with that in the US and is very, in my view, non-transparent in the way it assesses these transactions and the rationale behind them. UK, on the other hand, so far in the past regime has been very transparent. Other authorities, the transparency varies of the decision making. But I don't think national security is one that should be part of any competition regime.
Interesting. Bill, would you agree that as long as competition agencies are transparent about it, that's good enough? Or could there be a case that you cannot hit multiple targets with this arrow, and there is one arrow that you have, and the more you recognize other goals as goals to be pursued as a policy preference, the more you lose your ability to serve the prime objectives of competition laws, i.e., what they are more suitable to serve?
My starting point would be that I would never tell a country that it cannot effectuate specific policy concerns. That's their choice. They can define what they're trying to do with their competition law in any way they like. I would say that good practice would dictate that as you implement the framework, whether it has 2 variables or 20, your obligation from the point of view of good public administration is to explain clearly what you are doing. And as you add different variables, to explain what the hierarchy is among them and where there are conflicts, how you have carried out the trade-offs. I think the nervousness for many agencies when they have that kind of multi-variable mandate is that there's no good methodology for doing the trade-offs. And one feels nervous and awkward about explaining what you've done. And I think whether you're writing a paper, writing an examination, giving a talk, it's the point at which you're not sure about what you're doing. You're not confident in your methodology that you descend into a haze of obscurity where you don't put your rationale and logic on the table. Now, I think in South Africa, the Competition Commission of South Africa has done an admirable job of trying to put their cards face up on the table to explain what they're doing.
Yeah.
But that approach, I would say, is what one has to follow. That is, I could offer a normative view about how tractable certain types of considerations are in applying the standard. But a starting place for me is, I guess, the exhortation you get in a mathematics exam: show your work. Tell me how you did this. I think that in the course of being honest about those choices, I think it draws you back into trying to get a better answer to the question you pose, Gonench, which is this manageable? Can I do this? That is, in the effort to explain how I am applying these different considerations and how I am resolving tensions among them, I think that pushes you in the direction of asking whether your framework is feasible. But what you cannot do is descend behind a cloud, wave your hands and say, we looked at all the variables and this is the answer. I want to know how you got there as a way of, as a discipline, but also as a way of trying to move the analytical state of the art forward.
Yeah.
And I think a
So,
lot of agencies are really nervous about doing that, so that you're likely to get decisions that aren't completely honest. And another bit of nervousness I'll just mention is, you know, who usually does these trade-offs? That's a legislature. Those are elected officials. That's their job. And I think one reason that agencies, competition agencies, have retreated into the analysis of arguably more tractable factors is that they know that the more that they enter the field of making policy trade-offs in a complex equation where there are many variables, that's where legislators feel confident, comfortable stepping in and saying, that's what we do. And I'm going to second guess you so that your decisions are joined up more intimately with choices that elected officials are making. And they say, we belong in the room now because you're doing, in many respects, things that are really our job.
Thank you very much. For the records, again, just so that it's also featured in the visual, Anne Riley has written and said that she supports the approach Bill has also underlined, and I also underlined, which is more discussion is needed to integrate sustainability goals and to understand where the fear lies. Anne Riley, for those of you who may not know her, which would be a minority, I think, is someone with many decades of in-house experience in oil and gas as well, in an oil and gas company's competition law compliance matters at the top. And on the sustainability issue, the issue spotting needs to be made through more discussion, is what she's saying as well. Now turning to, Bill, go ahead, please.
I was wondering if I could take 1 minute to respond to Maureen's superb question about the insurance scenario.
Oh, that'd be great. Yeah.
And
please.
I don't. I think it's a fabulous query, and I guess part of what I don't know in that kind of assessment is how I would take into account the interests of the people who buy the electrons that are coming off of these coal facilities that aren't going to be insured. I mean, to what extent does their immediate interest in buying energy factor into my analysis? But I'd want to ask another question, and it's again this wonderful hypothetical. Suppose that a group of banks, mortgage lending companies say, well, part of what makes our lifestyle unsustainable is that we own too many homes, we consume too much housing, and we agree among ourselves that we will not issue mortgages for houses with a greater square meterage than this. That's too big. Nobody needs to live in a house like that. We will not insure a second home, or even worse, a third home. We just won't issue policies to cover that because that undermines sustainability. Human beings do not have to live that way. How would we feel about private initiative that seeks to discourage what perhaps in good faith the financial institutions in question regard as investments that are improvident because they discourage attainment of broader social objectives?
Very interesting. Very interesting. Thank you for that. Going to Ioannis, and cognizant of the fact that we have about 5-10 minutes, FDI regulation. So countries regulating foreign direct investments, where does this fit in competition law? Does it have to fit in competition law? But sure enough, you know a lot about it. And all private practitioners that primarily do competition law also get questions on FDI regulation. So how would you fit that in the goals of competition law? And I know, Ioannis, that this is a field that you've been looking into as well.
FDI is one of the areas that I would argue competition authorities should have nothing to do about, because it's to start with, it's even more political in nature than competition law. It covers much broader industrial policy considerations than what competition authorities are equipped or are destined, possibly at this point in time at least, to do. Adding one more consideration, it's easy to add one more consideration, but when it comes to the reality of this, when it comes to the authorities having to assess investments coming in, they will need appropriate resources to do so. They will need appropriate time to do so. I just do not see how that can be done by a competition authority. Better that can be done by a separate government or non-government body that has as its primary focus and expertise to do that. There are question marks that I at least hear in Brussels, whether DigiCom has all the stuff it needs to enforce DMA. So, and that's regulation of digital markets. That's not FDI. So let alone having to add something so different to an already very resource scarce competition authorities such as FDI. So I would not find a role for that in competition enforcement.
You did make your point on national security goals, but would you like to expand on national security goals being featured within competition law and why this would be an issue?
Because national security goals is not about how competitive the markets are or whether the consumers will become, it's whether we feel that a particular, for example, acquirer may have interests which will be against the national interest of our country, and this can relate to certain sectors or can be generic, depending on which country you look at. Competition authority, to be able to assess that, you need to understand, you need to have, for example, advice from your intelligence service colleagues, whether there is any particular state involvement in a foreign acquirer who will come to invest in energy in a plant next to your main city. So we are entering areas that are very non-transparent for very good reasons, and that will lead to even more problem on a competition authority's job to try and explain how we will block a deal on security grounds. Yeah,
this also brings me to the last idea that I would like to cover with the two of you, which is that some fields should not be, this is an assertion that I'd like to make, and I would like to know if you agree, some fields and some goals should not be integrated into the competition law analysis to protect the neutrality and the technical approach of competition agencies. National security goals are like that, for example. It would render any competition agency so political and so non-transparent that it's very difficult to have that very agency act in a very transparent and neutral way and insulated from political pressures as well when it comes to other files that don't have a national security goal. I could give the same example for competition agencies that are being pushed under the bus of enforcing in the field of state aid, for example. Why would any competition agency in their right mind want tasks on state aid is beyond me. They might be feeling, well, we're doing enforcement with teaspoon here, and they're doing a whole different ball game of imbalancing acts in the state aid field. We have very well educated people in our roster, so we could do good in state aid. But the minute you embrace state aid law dynamics within an agency that is supposed to do competition law enforcement, you are opening your corridors up to lobbying and to political influence, and there's no other way about it. Would Bill agree with this assertion, or do you think I'm too romantic about it?
I don't think you're too romantic about it. I say that with, I think, full appreciation for the motivation of including that mandate in the Treaty on the Functioning of the European Union. That as problematic as the inquiry is, the sense is that was indispensable to the creation and formation of the union. And they have found ways to live with precisely the tension and concern that you mentioned. And I would say that in some ways they made refinements and adjustments that reflect political realities to avoid getting run over by the bus that you just mentioned. I guess a role that as an agency official I would feel more comfortable playing is one that I suppose is anticipated in the internal market regime in the United Kingdom, which is acting as an advisor to government about the consequences of different kinds of state aid policies or different kinds of investment. Not necessarily to be in a position of vetoing specific investments, but in a position to say, here are side effects, consequences that you can anticipate if you spend your money this way. And if you make these kinds of investments, here are some readily anticipated effects. Here are others that you ought to think about. We're not going to tell you, the political decision makers, exactly what to do. You make the call. You are ultimately accountable to the electorate for these kinds of choices. But we are going to give you our advice and thoughts about the economic wisdom of making these kinds of investments. I guess I would be more comfortable with that advisory role, though I understand completely how taking this problem head on through the competition agency, which was seen as having the credibility to do the job, is seen by the European Union as this concern about market integration.
Thank you very much. And any last remarks and additions, Ioannis, before we draw this to a close?
No, just to echo what Bill said, EU can have 27 very, very selfish member states. So unless you have the state aid regime within the European Commission, you would not be able to have integration. Not that you have full proper integration now, but we would be a much worse situation than we are in EU.
Yeah. Wonderful. Thank you very much, Ioannis Kokoris and Bill Kovacic. It was an honor to moderate the two of you. I hope this was a 1 hour that was worthwhile for all of the audience. We will also circulate the link for the video recording of it for people who may have missed this wonderful gathering of two of the leading minds of competition law in the world now. And with that, I turn it over back to Nathan if he were to want to do closing remarks.
Just want to follow up on what you had to say. I thought it was really illuminating. I plan on actually watching it again later to make sure that I've caught everything that's been said. Want to thank everyone who's taken the time to watch this right now and on later viewings. I want to wish all of you all the best.